I request all the honorable dignitaries and participating officers kindly to occupy their chairs. The session would be commenced at 10 a.m. Kindly I request all the officers to take over their respective seats. I request all of you kindly to switch off your mobile phones or keep them in silent mode. And I request all the supporting staff kindly to stay outside this hall. Thank you. All the personal security officers, PSOs are requested to kindly go out of the hall, please.
Namaskaram, Vanakkam, Namaskara, Namaste. A very good morning to all. I am Sridevi SN, District Judge, Director FAC, Telangana State Judicial Academy. At the outset, I, on behalf of High Court for the State of Telangana and the Telangana State Judicial Academy, extend a very warm welcome to all the honorable judges, dignitaries and participants present here to the youngest state, Telangana, and to its vibrant capital, Hyderabad, which has got historical, cultural, economic and educational importance all over. It is a matter of pride that Hyderabad has been designated as a creative city of gastronomy by UNESCO. This city of pearls, which stands on the cusp of traditional values and modern technology and is a symbol of heritage, unity and vibrantly unique in hosting this regional conference on seminal topic, a topic of importance on use of technology in the judiciary, that is advancing rule of law through technology, challenges and opportunities. We are delighted to have among us for this inaugural session the Honorable Judges of the Supreme Court of India, Honorable Director, National Judicial Academy, Honorable Chief Justices and Judges of the High Courts, and the distinguished members of the District Judiciary from the states of Tamil Nadu, Kerala, Karnataka, Andhra Pradesh and Telangana, whose presence here reflects the shared and unwavering commitment towards strengthening of judicial landscape. I may now seek the permission of the Honorable Chief Justice and Patron-in-Chief of the Telangana State Judicial Academy to commence the inaugural session. Thank you, Milan. I deem it my privilege and honor to invite our distinguished dignitaries to kindly grace the dais as we commence the inaugural session. I now humbly invite Honorable Sri Justice Vikram Nath, Judge Supreme Court of India, to kindly grace the dais, and I request S. Govardhan Reddy, Registrar General, to escort His Lordship onto the dais. I request Honorable Srimati Justice N. Renuka Yara to kindly present a sapling to His Lordship. His Lordship is the first Chief Justice of a High Court in India to live stream the court proceedings on YouTube channel. It is my honor to invite Honorable Sri Justice Satish Chandra Sharma, Judge Supreme Court of India, to kindly grace the dais, and I request Sri Sura Srinivas Reddy, Registrar Administration, High Court for the State of Telangana, to escort His Lordship onto the dais. I request Honorable Sri Justice Nandikonda Narasimha Rao to kindly present a sapling to His Lordship. His Lordship was the Chief Justice of our High Court in 2021. Indeed, we are very much honored to have His Lordship today. Now I humbly request His Lordship, Honorable Sri Justice Aparesh Kumar Singh, the Honorable the Chief Justice, High Court for the State of Telangana, to adorn the dais, and I request V. Ramesh, Registrar Management, to escort His Lordship onto the dais. I request Honorable Srimati Justice E. Tirumala Devi to kindly present a sapling to His Lordship. His Lordship, being the Patron-in-Chief of Telangana State Judicial Academy, has always been a guiding force. May I now humbly invite Honorable Sri Justice Aniruddha Bose, Director, National Judicial Academy and former Judge, Supreme Court of India, to kindly grace the dais, and I request P. Sridhar Rao, Registrar Protocol, to escort His Lordship onto the dais. I request Honorable Sri Justice Madhusudan Rao sir to kindly present a sapling to His Lordship. His Lordship is known for judicial clarity and balanced constitutional reasoning. I now humbly invite Honorable Justice Maushmi Bhattacharya, Judge High Court for the State of Telangana and President Telangana State Judicial Academy, to kindly adorn the dais, and I request Jeevan Kumar to escort Her Ladyship. I request Honorable Sri Justice G. M. Mohiuddin to kindly present a sapling to Her Ladyship. Her Ladyship is widely appreciated for her contribution in the areas of civil, company, arbitration matters with specialization in corporate and intellectual property laws. Thank you very much. With the permission of the dignitaries on the dais, may I now request the dignitaries on and off the dais and all participating officers to rise for the national song, Vande Mataram.
Shashamana
Millets. May I now request the dignitaries on the dais to kindly light the ceremonial lamp to mark the inauguration of the conference. I now request all the participant officers and all the honorable judges to rise for national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I now request the dignitaries on the dais to kindly light the ceremonial lamp. The lighting of the lamp signifies the triumph of knowledge, wisdom, and symbolizes the dispelling of darkness and ignites the thought of enlightenment. It serves as a powerful reminder of the eternal nature of light, goodness, and its capacity to guide, purify, and alleviate the spirit. It signifies the belief that even in times of adversity or uncertainty, address the gathering.
It was giving some kind of electric shock. It's a shock to me to come to this place. Trust me. I'll, I'll elaborate it later. Namaskaram to everyone. Honorable Justice Vikram Nath, Judge Supreme Court of India. Honorable Justice Anirudh Bose, former Judge Supreme Court of India. Director, National Judicial Academy. Honorable Justice Apresh Kumar Singh, Chief Justice, High Court of Telangana. Honorable Justice Thakur, Chief Justice, Andhra Pradesh High Court. Honorable Chief Justice Mushtaq Ji. My brother and sister judges of the High Courts. Honorable Justice Mosmi Bhattacharya, Judge High Court of Telangana. Justice Venkat Rama Reddy, former Judge Supreme Court of India. Esteemed judicial officers from participating states. Esteemed members of the National Judicial Academy and Telangana State Judicial Academy. Resource persons for the technical sessions. Dear participants and all other who are in attendance. It's really a great privilege and honor to address this august gathering here in Hyderabad. I extend my sincere appreciation to the National Judicial Academy, the High Court of Telangana, and the Telangana State Judicial Academy for organizing this conference and for bringing judges together from across the region to deliberate on the issue that lies at the intersection of technology and justice. The presence of more than 130 judicial officers from several high courts reflects a shared commitment for strengthening our justice delivery system and advancing the rule of law in the present technological landscape. I'm personally grateful to Justice Bose and Justice Apresh Kumar Singh Ji, who were kind enough to invite me to come to this place after 4.5 years. I don't know, they might have sent invites earlier, but they never reached me. Delhi is a big place. Addresses are difficult to find addresses. I must tell everyone that these institutions doesn't belong to individuals. These institutions belong to the nation, to the people. I'm once again very, very grateful to you, Apresh Ji and Bose Saab, for inviting me and for bringing me near to my dear ones and near ones with whom I have worked for more than 1.5 years. And that was, I must say, that was my best period. It was like a family. So I'm back in the family. Allow me to begin with a brief reflection. For centuries, courts across the world functioned with handwritten pleadings, bound volumes of law reports, and physical courtrooms where justice was administered within the four walls of the courtroom. If a judge needed to find a precedent, it often required hours of searching through printed law journals and digests. Today, within seconds, a judicial officer can access thousands of judgments, statutes, and commentaries through digital database. Court hearings can be conducted across the cities and even continents. Technology can assist in organizing case material and identify relevant precedents. There's no doubt that technology is transforming justice delivery. While the principles of justice remain constant, the tools through which justice is delivered are evolving. Today, we are living in a time where technology is transforming almost every sphere of human activity, be it governance, commerce, education, healthcare, and the justice system. Courts today are no longer confined to physical courtrooms and paper files. Digital platforms online databases, and artificial intelligence are gradually becoming part of the judicial ecosystem. In India, judiciary has taken significant steps towards embracing technology. We have seen this transformation through the ongoing e-courts mission mode project, which has significantly strengthened digital infrastructure across the judiciary. Electronic filing of cases, virtual hearings, online case lists, digital case records, and the availability of judgments on public portals have made the justice more transparent and accessible than ever before. The Supreme Court of India has also pioneered innovative tools that demonstrate how technology can support judicial work. One such initiative is SUVAS, Supreme Court Vidik Anuvad software, an AI-powered translation system that enables the translation of judgments into multiple Indian languages. By breaking linguistic barriers, this technology expands access to justice and brings the law closer to citizens across the country. The technological advancement in justice system is not limited to court administration alone. It is also reflected in a recent legislative reforms. Technology has therefore opened new opportunities for advancing the rule of law. First, it has the potential to enhance access to justice. Citizens from remote regions can also access court proceedings without burden of traveling and expenses. Litigants can track their cases online. Lawyers and judges can access databases instantly. In a country as vast as diverse as ours, such digital access is a powerful instrument of inclusion. Second, technology can improve efficiency within the justice delivery system. AI tools are increasingly capable of assisting with legal research, documents analysis, and case categorization. These tools can process large volumes of information within seconds, helping judges navigate complex legal material. But it is important to emphasize that technology must remain an aid to judicial decision making, not a substitute for it. Judicial reasoning is not merely a mechanical process. It requires interpretation, balance, empathy, and a deep understanding of human circumstances. Algorithms may identify patterns, but justice often lies in recognizing the exception rather than the rule. Therefore, while technology can assist the judiciary, the final responsibility of judging must always remain with the human mind and the human conscience. Technology also presents serious challenges. One such challenge is risk of algorithmic bias. Artificial intelligence systems learn from existing data. If the data reflects historical biases or social inequalities, the outcomes generated by such systems may unintentionally reproduce those biases. In a diverse society like ours, this requires careful scrutiny. Another challenge is data protection and privacy. Courts handle highly sensitive information like personal data, financial records, medical reports, and confidential testimony. As judicial system becomes more digitized, safeguarding this information becomes a matter of paramount importance. For the judiciary, the challenge is not simply to adopt technology, but to adopt it wisely. Technology may provide us with powerful tools, but it is the judicial mind and the judicial conscience that gave meaning to the rule of law. No algorithm can govern a human soul. As we gather here over the next 2 days, this conference provides us the opportunity to reflect on these issues, share our experiences, discuss challenges, and explore best practices in integrating technology with judicial processes. The technology may transform the courtroom, but it is the commitment of the judges to fairness, independence, integrity that ultimately sustains the rule of law. Now, these days, this video conferencing has become very important. We can hear a lawyer sitting in Kerala arguing a case before the Supreme Court. It's my personal opinion, exclusively personal opinion. But some of us have also started doing cases sitting at home while on holidays through video conferencing. You are a judge. You are required to come to the courtroom. In emergencies, it's okay. Once or twice, it's okay. But it should not become a routine habit. So my request is, in case of emergency, of course, you're welcome to do it. But otherwise, it should not become a routine for us at least. Because tomorrow, you expect the district judge to come at 10:30 to the courtroom and leave by 6 or 7. He will also say, fine, I'm at home, I'll do cases through video conferencing from 10:30 to 5:30. So there has to be some restriction on this. For at least for us, not for litigants and not for lawyers. Secondly, Chief Justice was talking about a case on reservation. In fact, that case was from Punjab, but it was connected with a case from Telangana. There's a particular caste in Telangana. Not a single member of that caste is holding government post. Not a single member has become an IAS officer. Unfortunately, after 76, 78 years of independence, they're the still most downtrodden people in this state. For them, a law was enacted in Telangana to give them preferential treatment within the reserved class. And that matter went to Supreme Court. And of course, Justice Gavai wrote the main judgment, and I was part of it. And we held that yes, reservation within reservation is permissible. And Honorable Justice Gavai also went to the extent of concept of creamy layer for scheduled caste and scheduled tribes. Though now he's not holding the post, but I must, with great respect to him, tell you, while we were discussing the case, he said, Satish, my father was a governor. He was a cabinet minister. I am Chief Justice of India. And now time has come to think whether my son wants a reservation or not. And therefore, he introduced the creamy layer concept. So they are great people, really great people. With these words, I extend my best wishes for the success of this conference and look forward to the discussions that will follow. And Aprishji, please keep on calling me. I love this place. Thank you so much and Jai Hind.
Thank you, Your Lordship, for that inspiring address and for setting a thoughtful direction for the discussions ahead. I now have the honor of inviting Honorable Sri Justice Vikramnath, Judge Supreme Court of India, to kindly deliver the inaugural address.
A very warm good morning to everyone. My esteemed colleague, Brother Justice Satish Chandra Sharma, on the dais, Chief Justice of the Telangana High Court, Justice Aparesh Kumar Singh, my elder brother, good friend and former judge of the Supreme Court, presently Director, National Judicial Academy, Justice Aniruddha Bose, Director of the Telangana State Judicial Academy, Justice Maushami Bhattacharya, Honorable Chief Justices of the State of Andhra Pradesh High Court and Sikkim High Court, Justice Dheeraj Singh Thakur and Justice A. Mushtaq Mohammed, Senior Judge of the Telangana High Court, Justice Sam Koshi, former Judge of the Supreme Court, Justice Ramareddy, judges, honorable judges from the Telangana High Court and all other participating high courts, distinguished judicial officers from all the participating states, Registry of the Telangana High Court, other participants, distinguished resource persons, print and electronic media. It is a pleasure to be here in Hyderabad for this regional conference on advancing rule of law through technology, challenges and opportunities. Hyderabad is a fitting place for this conversation. It is a city where history and innovation stand side by side, where enduring institutions and new possibilities constantly meet. In a sense, that is also the space in which the law finds itself today. Dr. B.R. Ambedkar once reminded us that constitutional morality is not a natural sentiment. It has to be cultivated. That insight remains profoundly relevant even today. Technology may be transforming the conditions in which law operates, but the values that must guide our response to it cannot be accidental. They too must be cultivated. If technology is to serve the rule of law, it must be approached with constitutional discipline, institutional responsibility, and a clear sense of justice. We are living through a time when technology is no longer external to the administration of justice. It has entered the way we communicate, the way we store and assess evidence, the way courts function, the way lawyers prepare, and even the way ordinary citizens understand the justice system. So, the real question is no longer whether technology will shape the future of law. It already has. The real question is whether we, as a legal community, will shape that relationship with wisdom, balance, and constitutional fidelity. Over the course of this conference, there will be important discussions on the digital divide, e-services, alternate dispute resolution, electronic media, cybercrime, digital forensics, and artificial intelligence. These themes may appear distinct, but they are connected by a common set of questions. How can technology strengthen the rule of law rather than weaken it? How can it make justice more accessible without making it more impersonal? How can it improve efficiency without compromising fairness? And how can it widen the doors of the court without diluting the discipline, seriousness, and humanity on which the justice system rests? The legal community cannot afford two equal and opposite mistakes. The first is to reject technology simply because it is unfamiliar. The second is to embrace it uncritically simply because it is new. Neither instinct serves the law well. Technology must be approached neither with fear nor with fascination, but with responsibility. If we are to speak of technology advancing the rule of law, we must begin with access. E-services, digitized records, online filing systems, and virtual platforms have opened important possibilities. They can reduce distances that were once physical, financial, and procedural. They can make the system more navigable, more efficient, and in many cases more accessible. But access in the digital age must be understood more deeply. The digital divide is not merely a divide of devices or connectivity. It is also a divide of language, literacy, confidence, and familiarity. A service may be technically available, yet still remain effectively out of reach. If justice is increasingly mediated through technology, then genuine digital inclusion becomes part of ensuring equal access to justice itself. That is why technological reform cannot be measured only by innovation. It must also be measured by usability. We must ask whether a litigant in a remote area, a senior citizen unfamiliar with digital systems, a young lawyer beginning practice, or a person with limited means can actually use these systems with dignity and confidence. The real test of progress is not whether the system becomes more advanced for a few, but whether it becomes more accessible for many. Technology in the justice system must therefore be simple, reliable, affordable, and user-oriented. It must reduce procedural burdens, not create new anxieties. Many of us also know that technology can appear highly efficient until the microphone fails, the screen freezes, or the internet decides that it too is entitled to a day in court. But that only reminds us that our systems must be robust, dependable, and built around the user. The same broad principle extends to alternate dispute resolution. Technology can make mediation and similar processes more efficient and more widely available. But even here, technology is only an enabler. The heart of mediation remains human dialogue, trust, patience, and understanding. A screen may facilitate conversation, but it cannot itself create empathy. Another important way in which technology can strengthen the rule of law is by making the functioning of courts more visible and more intelligible to the public. In that context, live streaming of court proceedings is a development of real significance. Many have a different view on this. I have a different view. I have long believed that with proper safeguards, it can save transparency, accessibility, and legal awareness. Live streaming can bring the courtroom closer to the citizen. It allows young lawyers, law students, researchers, and members of the public to witness the discipline of proceedings and the seriousness with which legal questions are examined. In doing so, it can deepen public understanding of the legal process and make the court less distant in the public imagination. At the same time, we cannot ignore the difficulties that accompany such openness. In the age of instant circulation, courtroom clips are sometimes shared selectively, posted without context, or edited in a way that distorts the true tenor of proceedings. A serious exchange may be reduced to a few seconds. A complex legal issue may be converted into a slogan. Nuance is lost, and with it, public understanding. But the answer cannot be to retreat from technology altogether. The answer lies in safeguards, responsible norms, and informed public engagement. The misuse of a tool is not by itself a reason to abandon its legitimate use. The same is true of electronic and digital media more broadly. Technology has given every person a voice, and that is in many ways a democratic gain. But it has also made it easier for misinformation and sensationalism to travel faster than accuracy. Transparency must strengthen trust, not be converted into spectacle. The legitimacy of the judiciary rests on fleeting impressions, but on fairness, restraint, and reasoned decision making. Our discussions on cybercrime and digital forensics take us into an area where the law is being tested by the speed of technological change. Courts today increasingly encounter digital frauds, online deception, identity theft, and financial scams. These are no longer exceptional occurrences. They are part of the everyday legal reality of our times. Technology has changed not only the manner in which many offenses are committed, but also the manner in which evidence is created, stored, altered, and recovered. Evidence may now lie in devices, cloud servers, deleted messages, transactional logs, and metadata. This makes investigation and adjudication more complex. But complexity cannot become an excuse for uncertainty in principle. However sophisticated the technology may be, the court's task remains constant: to insist on authenticity, reliability, fairness, and due process. That is why the answer to cybercrime cannot be to step away from technology. Withdrawal is not a solution. The answer lies in awareness, stronger institutional capacity, better investigative tools, and a deeper understanding of digital systems. The law must equip itself, not isolate itself. That brings me to artificial intelligence. AI is often spoken of either with exaggerated fear or exaggerated confidence. In my view, neither is helpful. The legal community should not shun AI altogether. Equally, it must not treat AI as a substitute for legal thought, professional training, or judicial reasoning. AI, properly understood, is a tool. It may assist in organizing material, summarizing documents, identifying patterns, or improving efficiency. Used intelligently, it may save time and make some aspects of legal work more manageable. But a tool must remain a tool. It cannot replace the trained mind of a lawyer, the ethical responsibility of an officer of the court, or the disciplined judgment required of a judge. We have already seen disturbing instances where AI generated material has been used carelessly, even in the Supreme Court, including references to citations and authorities that do not exist. That is a matter of serious concern. False citations are not merely technical mistakes, they strike at the integrity of legal submissions and the credibility of the adjudicatory process itself. Technology may help draft a note, but it cannot be permitted to invent the law. At the same time, the misuse of AI cannot lead us to the opposite extreme of refusing to engage with it altogether. The answer is informed use, ethical discipline, and professional standards. We must learn how to use these tools efficiently, carefully, and with full awareness of their limitations. Therefore, the challenges before us are real. Technology can widen access, but it can also deepen exclusion. It can increase transparency, but it can also encourage distortion. It can assist legal work, but it can also create new forms of carelessness. It can help us respond to crime and at the same time become the means through which new crimes are committed. That is the paradox of the age we live in, but it is also the responsibility of our institutions to respond to that paradox with wisdom. Sorry. Our approach, therefore, must be one of principled adaptation. We must not reject technology because it is new. We must not accept it blindly because it is efficient. We must evaluate it through the lens of constitutional values. The future of the justice system will not be secured merely by digitizing procedure. It will be secured by ensuring that technology remains anchored to the foundational ideals of the legal system. The rule of law ultimately depends not on the sophistication of our tools, but on the soundness of our institutions and the integrity of those who serve with them. If in the years to come we are able to say that technology helped us bring courts closer to citizens, improved efficiency without weakening fairness, strengthened transparency without sacrificing seriousness, and enhanced legal work without displacing human judgment, then we would have used this moment well. On that hopeful note, I thank the organizers, the dignitaries present here, and all the participants who have gathered for this important conference. I am sure the deliberations over the course of the day will be enriching and constructive. May we continue to move forward with openness to innovation, but with our constitutional compass firmly in place. Before I extend thank you, let me also express my feelings for the city. This is the second time I am here in Hyderabad. Earlier I was here last year, and I love this city. The weather, the breeze, the environment, the buildings, the people here. So I would also request the Chief Justice to invite me again and again, and I'll keep coming. I will make him a request to allow me to address the judicial officers on some day and the Director Judicial Academy to hold a 2-hour, dialogue or interactive session with the judicial officers of the state. And this I wish to carry to every state, and just some of their ideas I will take and some ideas of mine I will share with them, so that we can do better and strengthen the faith of the public in the judiciary. So with that note, let me extend a thank you to everyone.
Thank you, Your Lordship, for that thought-provoking inaugural address and for setting the concept for this conference. Now I request my colleague to take over these proceedings.
It's now time to pay our respects to all our honorable dignitaries on the dais by felicitating them. I now humbly request Honorable Sri Justice J. Srinivas Rao Garu kindly to present a shawl to our Honorable Chief Guest, Honorable Sri Justice Vikram Nath Garu, Judge Supreme Court of India. And I humbly request the Honorable the Chief Justice Sri Aparesh Kumar Singh Garu, High Court for the State of Telangana, kindly to do the honors with a memento as a token of respect to the Honorable Chief Guest. Next. Thank you, my lords. I now humbly request Honorable Sri Justice S. Chalapati Rao Garu kindly to present a shawl to Honorable Sri Justice Satish Chandra Sharma Garu, Judge Supreme Court of India, and I humbly request the Honorable Sri Justice K. Lakshman Garu, Judge High Court for the State of Telangana and Member Board of Governors of the Telangana State Judicial Academy to kindly present a memento as a mark of respect to His Lordship. Thank you, my lords. I now humbly request Honorable Sri Justice Vakiti Ramakrishna Reddy Garu kindly to present a shawl to Honorable Sri Justice Aparesh Kumar Singh Garu, Honorable Chief Justice, High Court for the State of Telangana. And I also humbly request the Honorable Sri Justice B. Vijaysen Reddy Garu, Judge High Court for the State of Telangana and Member Board of Governors of the Telangana State Judicial Academy to kindly present a memento as a mark of respect to the Honorable the Chief Justice. Thank you, my lords. I now humbly request Honorable Sri Justice Gadi Praveen Kumar Garu, Judge High Court for the State of Telangana, kindly to present a shawl to the Honorable Sri Justice Anirudh Bose Garu, Honorable Director, National Judicial Academy. And I also humbly request Honorable Srimati Justice T. Madhavi Devi Garu, Judge High Court for the State of Telangana and Member Board of Governors of the Telangana State Judicial Academy to present a memento as a token of respect to the Honorable Director of NJA. Thank you, my lords. I now humbly request Honorable Srimati Justice Jubadi Sridevi Garu, Judge High Court for the State of Telangana, kindly to do the honors to Honorable Justice Maushami Bhattacharya Garu, Judge High Court for the State of Telangana and Honorable President of Telangana State Judicial Academy with a shawl and also a memento as a mark of respect. Thank you, my lords. As we come to the concluding segment of the inaugural session, I now request Honorable Justice Maushami Bhattacharya Garu, Judge, High Court for the State of Telangana and Honorable President, Board of Governors of the Telangana State Judicial Academy, kindly to propose vote of thanks.
It's difficult for me to give my vote of thanks without smiling because I have so many friends sitting in front of me and my very distinguished panelists, Justice Vikram Nath, Justice Satish Chandra Sharma, Judges of the Supreme Court of India, Chief Justice of the Telangana High Court, the Director of the National Judicial Academy, Chief Justices of the Andhra Pradesh and Sikkim High Courts, my amazing Board of Governors who have been absolutely, I don't have words to describe their kind of support and encouragement, my very respected colleagues from my own High Court, the High Court of State of Telangana, for the State of Telangana, resource persons, dignitaries from the other High Courts, so many friends here, and judicial officers who have been so encouraging to all of us. The superb registry of the High Court of Telangana, they have been with us till 11:30, 12 last night here in the hotel, looking after everything. I could not have expected for a better teamwork. The Telangana State Judicial Academy, my team from there, our team from there, the Member Secretary of the Telangana State Legal Service Authorities, participants, press, and everyone, including my staff members who are here, all our staff members who are here, the support persons. So I have collected small little quotes to show the kind of participation in depth and the engagement, the deep engagement of my very distinguished panelists to the cause of technology and justice. And we have heard a very rounded kind of approach to technology and justice from my very distinguished panelists. It's not only a good approach, but it's also a very realistic, thought-provoking approach where technology is recognized for its advancement, advancing the cause of justice, but also its limiting powers, the realities, the ground realities, which we must keep in mind always. So where Justice Vikram Nath is concerned, I remember I was so moved by Master Bholu judgment at one point of time, juvenile justice, and then with regard to technology, small quotes, I have kind of written it down. Technology can assist, but it cannot take over the role of human judgment. Justice is at its core human. Human qualities such as compassion, understanding of social context, and ethical judgment are essential in legal decisions. If arbitration was designed to save time, then AI has the potential to redefine what time even means in dispute resolution. Very interesting. Most AI operate as a black box. In law, reasoning is not optional. A judgment without reasons is not a judgment at all. If the data reflects social prejudices based on race, caste, gender, or economic status, the algorithm produced and sometimes amplifies these biases. Then just last two quotes. AI can support judges, lawyers, and litigants by enhancing access, reducing delays, and assisting in research. But the ultimate act of adjudication must remain a human function guided by conscience and constitutional values. And lastly, let's make technology our junior, not our judge. When it comes to Justice Satish Chandra Sharma, a few quotes. Advocates and judges must both be mindful of their language, because in today's digital age, everything said in the courtroom is being reported. That is something which Justice Vikram Nath cautioned a few minutes ago. Then again, Justice Satish Chandra Sharma, technology is helpful but can be dangerous, especially with judicial officers and advocates using digital platforms where speech and statements can be recorded and circulated. And lastly, integrating technology simplifies judicial processes and improves accessibility, transparency, and efficiency in justice delivery. When it comes to Justice Aniruddha Bose, very interesting sentence which he coined is, advancement of the rule of law must keep pace with technological progress to prevent the emergence of a digital apartheid. So kind of bringing together sociology, technology, justice, everything. And again, a cautious use of AI in courts. AI and other advanced tools should be used cautiously and responsibly to support justice and not to undermine justice. And lastly, information technology has made a huge difference in making the system work for common people. So a very balanced, a very compassionate approach to technology and justice as well. And lastly, what I found interesting in Justice Bose's judgments and comments is that the importance of use of regional languages, which would make the legal system more understandable and inclusive for ordinary citizens. And how can I miss my Chief Justice? 2016 decision of when our Chief Justice was a judge of the Jharkhand High Court. That's Shagun versus State of Jharkhand. That's a 2016, it's a reported decision, where the case actually involved on a biology question paper in the Jharkhand Combined Entrance Competitive Examination, CET, which was held in 2016. And this particular biology examination paper had been captured and circulated via WhatsApp and mobile phones using digital device, which was then leaked, and the examinees got wind of what that question paper was, the questions were. And Chief Justice Aparesh Kumar Singh, then a judge of the Jharkhand High Court, highlighted the implication that judicial supervision ensures transparency and accountability in cybercrime investigations and maintains integrity in handling digital evidence. And in 2016, cybercrimes was not as common a concept or as common in everyday parlance as it is now. And the implication also that technology and scientific expertise can be effectively integrated into judicial processes for evidence validation and management. So welcome and thank you in advance for being here, all of you. And if I've missed anyone, I think I may have missed the wonderful coordinating team from the National Judicial Academy who are here. I hope I have not missed anyone. Of course, we are very happy to have Justice Venkatarama Reddy amongst us. Thank you very much for being here, sir. And so just flagging off with a vote of thanks, which was not really meant to be a vote of thanks, but more highlighting the theme of our conference this time. Thank you very much and have a wonderful conference. Thank you.
Thank you, Mallards. May I now request the technical team to play a short film on Mobile Lok Adalat of Legal Services Authority.
Telangana State Legal Services Authority welcomes you. As per the instructions of NELSA and the directions of the Patron-in-Chief and the Executive Chairman of the Telangana State Legal Services Authority, two multi-utility vehicles have been purchased. These vehicles will help in addressing the legal needs of the public, especially people living in remote areas. By using modern technology, these vehicles will provide quick access to legal assistance and justice for victims. The vehicles will provide the following services, providing free legal aid and legal support to litigants without any cost. Conducting legal awareness camps in villages, especially for weaker and vulnerable sections of society. Guiding affected individuals about their legal rights, entitlements, and the steps required to seek compensation or relief. Promoting the schemes launched by NELSA and the Government of Telangana for party alleviation and public welfare. Displaying short films produced by TSLSA on various legal topics to create awareness among the public. Conducting mobile Lok Adalats to help resolve disputes quickly and amicably. Providing video conferencing facilities so that victims in remote areas can consult lawyers easily. These vehicles will serve as mobile legal service units, bringing justice and legal awareness closer to the people.
I now request all the dignitaries and participants kindly to join us for a group photograph in this hall. And after the photograph session, there will be a flagging of the mobile Lok Adalat van by the Honorable Sri Justice Vikramnath, Honorable Judge, Supreme Court of India and Executive Chairman, National Legal Services Authority, and the dignitaries on the dais, and the Honorable Sri Justice P. Shyam Koshi Garu, Judge, Honorable High Court for the State of Telangana and Executive Chairman, State Legal Services Authority, and Honorable Sri Justice K. Lakshman Garu and other dignitaries would join the flagging of the mobile Lok Adalat van, and all the dignitaries and participating officers are requested to join us for IT at room numbers 4 and 5 for the Honorable Judges and dignitaries, and for the participating officers at foyer area opposite to this conference hall. And I request all the participants to reassemble in this hall by 11:30 a.m. sharp, as we would start the technical sessions. Thank you one and all. Thank you. All the honorable judges and the participating officers are kindly requested to
Check, check, 1, 2, 3, check, mic check, 1, 2, 3, హలో చెక్ చెక్ ఛానల్ 2లో ఇచ్చిన అని చెప్పన్న. అరే వర్రాక రాగరా. చెక్ 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 చెక్. చెక్ 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 హలో వస్తుందా?
All the respected nominated participating judicial officers from different states, they are requested to kindly join for the photo session.
నిమిషం. దిస్